Thank you. Well, Lance, thank you. He is. But I don't see, sometimes I just don't remember everything. No, I think keep it. Thank you. Just thank you.
I'm gonna go check and see what you're here.
Here he comes.
Yes, ma'am. Yeah. When would that have been? He wants to cut you off mid-sentence, he'll cut you off mid-sentence. Maybe you should take
If you want to adjust the height of the podium, Mr. Reese, you can adjust the podium this way. I'm sorry I interrupted you. Okay?
Great.
It's up to you.
Okay. Thanks.
So I please ask everyone to turn your cell phones off, any palm pilots, anything, any electronic devices. Thank you.
First, didn't he?
I didn't see anything.
Okay, great. Thanks, Lance.
Sorry. We've got. And if we need something like over, somebody's gonna have to probably somewhere out on the side of it.
All rise. The judges of the United States Court of Appeals. Hear ye, hear ye. The United States Court of Appeals for the Sixth Circuit is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. God save the United States and this honorable court. Please be seated.
Good afternoon. Welcome to the Sixth Circuit. I believe we have the same lawyers arguing each of these appeals. Is that correct? All right, we're going to start with the individual plaintiff preliminary injunction appeal. I think that's the lower case number, if I recall. So we'll just argue that. And obviously, there'll be some overlap between the cases today, and that's fine. But we don't want to focus on, say, some Rule 23 issue, in the individual plaintiff case. That said, you've each got 25 minutes in each case, so we'll be here for a while. And the clerk may call the first case.
223497, Hunter Doster et al. Versus Frank Kendall et al. Arguments not to exceed 25 minutes per side. Mr. Ross for appellants.
Wherever works for you.
Thank you, Your Honor. Kason Ross for the United States, and with me at counsel table is Major Mark Nowak from the Air Force.
Very good.
The named plaintiffs failed to satisfy any of the requirements for a preliminary injunction. Plaintiffs' claims under RFRA and the Free Exercise Clause are meritless. The Air Force plainly has a compelling interest in ensuring that these deployable service members are able to fulfill their missions anywhere around the world. And no alternative can satisfy those interests to the same degree as vaccination against COVID-19. And on the equitable factors, plaintiffs fare no better. Plaintiffs have not been able to identify any irreparable injury during this litigation. The consequences they may face for failing to comply with the vaccination requirement are employment-based harms that this court, the Supreme Court, and indeed the district court itself acknowledged are plainly compensable and quintessentially reparable.
Is there any difference between the harm in the military context versus a typical employer context for reinstatement in the military? Say you got a remedy ultimately of reinstatement in the military, if they were discharged.
Yes.
As far as the back pay goes, is there any difference in the military rules of what you can get for back pay versus in the private sector?
I'm not sure exactly what would be available in the private sector, Your Honor, but 10 U.S.C. 1552 provides quite broad authority for the Board for the Correction of Military Records to afford pay for almost any reason. And discharge would be one of those reasons, including back pay. Courts have emphasized that the degree of irreparable injury required for Courts have emphasized that the requirement of irreparable injury is heightened in the military context. And that's why a number of courts have held that even discharge from the military does not amount to irreparable harm.
What about, I think it's kind of black letter law that violation of constitutional rights, free speech rights, free exercise rights, that's irreparable injury per se. So why wouldn't that apply here? Setting aside, so there's tangible injuries. The tangible injuries are economic, their duty of reassignment, and then there's the intangible injury of being pressured into violating your religious beliefs.
I think there's actually two questions there, Judge Murphy, which is one, the pressure question, and the other, which is the merits question. On the merits, that I think puts the cart before the horse in some ways because, as we've argued, the plaintiff's claims are meritless. There's no...
You know, there's a chance we might disagree with you.
Sure.
If we're just talking about irreparable harm, then
So-
we ought not to, conflate the two.
Yes, so the Supreme Court held in Elrod that a constitutional violation of the First Amendment would likely constitute irreparable injury for purposes of a preliminary
Does
injunction.
that mean if we, I know you disagree on the merits, but does that mean if we agree with the plaintiffs on the merits that they've already established irreparable harm?
I think there are actually separate irreparable injuries here that plaintiffs have been unable to substantiate. And it's also worth noting that this court has never endorsed that same reasoning with respect to RFRA.
I was gonna ask about that, if you had a position on whether we should treat the violation of the Constitution as an irreparable injury and perhaps not RFRA because it's statutory. What would be but it's still the same. Congress passed the statute to further the same interest in exercise of religion. So why would the statutory right differ from the constitutional right?
As a doctrinal matter, the Supreme Court only extended the holding in Elrod to constitutional violations. And I think just as a matter of separation of powers and the difference between constitutional and statutory injuries, there is an important distinction there. But moreover, RFRA itself simply codifies a standard of review for purposes of certain kinds of claims. And Congress was, in some ways, overruling the Supreme Court's holding in Smith with respect to the federal government. And that it did so would not necessarily go to what is required for irreparable injury for purposes of a preliminary injunction.
Do you think it's a matter of statutory interpretation or congressional intent, whether we should treat this as a irreparable injury? By which I mean, what would Congress have expected to have happened?
Frankly, I'm not sure, Your Honor. That question certainly hasn't been briefed in this case. And I suppose it's just as a doctrinal matter, it would be a question of the text of the statute. Certainly, Congress is within its authority
That's
to...
can we flip, so we're at the tail end of the issue.
Of course, yes.
If we flip to the beginning and justiciability, so it seems to me that the plaintiffs have two causes of action. One is under RFRA, and one is, as far as I can tell, correct me if you think I'm wrong, but under Ex parte Young or the judicially made private right of action to enjoin constitutional injuries. And that would be the First Amendment claim. And so why, you have this argument citing Harkness that these claims should be non-justiciable under this balancing test that Harkness incorporated from the Fifth Circuit.
Right.
Why do we think that that should apply to a statutory cause of action? Wouldn't Congress have said it wanted those limits to apply in the text of the statute if it wanted those limits to apply?
So Harkness itself, Your Honor, applies the justiciability requirements that this court adopted from the Fifth Circuit in both statutory and constitutional.
I guess I disagree with your reading of Harkness. Harkness had two claims. The first claim was this esoteric claim that I've been reassigned duties or missed duties in retaliation for my speech. It was not at all clear what the cause of action for that claim was, and that's where we applied the judicial balancing test. It strikes me that that might have been an Ex parte Young type action. Fine. But then when the court got to the statutory cause of action over the review boards, it considered the merits. It didn't say this is not justiciable. It said Congress created this cause of action, that you didn't invoke a review board. It's judicially reviewable. That's what Congress said. We're going to review this. And then they rejected the Establishment Clause claim. RFRA strikes me as analogous to the portion of Harkness that didn't apply the non-justiciability test.
Respectfully, I disagree, Your Honor, especially because, and at risk of sounding like I'm talking out of two sides of my mouth, the constitutional valence of RFRA claims, which is that, Congress was noting the important protections required for religious liberties, especially when the federal government is concerned, and sought to instantiate those protections by statute. And
But in this case, I mean, as to the RFRA claim, I mean, if you want to think of this as a claim, as you put it, with a constitutional valence, and you have Congress in the text of the statute, I think quite specifically directing us to adjudicate this as against any branch or instrumentality of any kind as to the government, which would seem to preclude the idea that we can't adjudicate this RFRA claim against the military. I mean, clearly Congress's language encompasses the military, so what would your response to that be?
Absolutely, Your Honor. And I want to be very clear that it is not the government's position that RFRA does not apply to the military. Rather, it is, at the present juncture, plaintiffs' claims are non-justiciable because they haven't been presented to an Air Force board for correction of military records or an Air Force district.
But where do we have the power to impose this exhaustion requirement on a statutory cause of action that Congress created that has no kind of judge-made common law exhaustion requirement?
So the Mindis test that this court adopted in Harkness is a judge-made abstention doctrine that, out of respect for separation of powers, courts have recognized the need to exhaust intra-service remedies first.
Separation of powers. I mean, Congress told us to adjudicate this, and yet we're going to interpose a judge-made doctrine, also notwithstanding our unflagging duty to exercise our jurisdiction. We're going to just set all that aside based on some judge-made balancing test and say, no, after all, we're not going to adjudicate this?
So I think the court did something of that sort in Autocam v. Sebelius, where in a RFRA challenge to the Affordable Care Act's contraceptive mandate requirement, that the court dismissed the case for lack of prudential standing. And that was a RFRA case.
That's a good example of why we shouldn't be doing this, because in a case called Lexmark, the Supreme Court says there's no such thing as prudential standing. It says it's a judge-made doctrine, and you can't impose judge-made doctrines on top of statutory causes of action, which is exactly what you're asking us to do here.
So even if you disagree with our position on justiciability, I will just note for purposes of this case that we only contend that the claims are justiciable right now. They could be justiciable in the future and may ripen in the future. But on the merits of the claims, it's worth noting that the Air Force plainly has a compelling interest in ensuring that these service members are deployable. And the best way to make sure of that is that they're vaccinated against COVID-19. There's simply no alternative that will accomplish the same goal.
What does this have to do with justiciability?
Sorry, Your Honor. I was simply saying that I had taken our colloquy to that you disagree with our arguments on justiciability, so I tried to move to the...
Oh, okay, I'm sorry. No, it's your prerogative to sort of, move on to another argument.
I'm happy to answer additional arguments about justiciability.
I mean, the other thing is that Congress did know how to create an exhaustion requirement, obviously. They've done it
we see it.
in many different contexts. And so, there's nothing, in other words, you don't have anything you can point to in the text to support an exhaustion requirement here.
Not with respect to RFRA itself, Your Honor, but rather that in the military context, courts have held in a number of cases, including cases involving religious liberty and constitutional claims, that there is something akin to an exhaustion requirement simply to allow the military to apply its expertise to each service member's circumstances before it comes into federal court. These are complicated questions about each person's deployability, their duties, and those are questions that the military should have an opportunity to answer first.
Can I ask, that led to one final question. What do you make of, if you have the text of RFRA in front of you, I don't know if you do, there's the provision that says, where is it? It says, standing to assert a claim or defense under this section shall be governed by the general rules of standing under Article 3 of the Constitution. So this is the judicial relief provision. Mm-hmm. I was curious if you had a position on what that meant. I mean, under kind of the expression of one thing is the exclusion of another, you could interpret that to be a congressional judgment that so long as the core Article 3 standing requirements are met, that is all that's required, and we shouldn't be imposing anything else. But I'm happy to be wrong about this if you think there's a better reading of why Congress would put this language that we have to follow Article 3 of the Constitution, which of course we'd have to follow anyways, even if they hadn't put that in. What's the point of that sentence? have an opinion on.
I'm not completely sure, Your Honor, but I will reiterate that we have made ripeness arguments with respect to most of the named plaintiffs here, that their claims are not ripe.
So ripeness is both constitutional
And prudential.
and prudential. So clearly the constitutional, even if they hadn't said this, we'd have to have the constitutional. But I was curious whether would that suggest that maybe there is no such thing as prudential ripeness even in the RFRA context? Because they suggested that the only justiciability concerns we should be thinking about are those that are imposed by Article 3 of the Constitution?
I guess my best answer is that this court didn't say that in AutoCam, and so where it dismissed the case for lack of prudential standing. That case was obviously subsequently abrogated by the Supreme Court, but I think the reasoning still stands.
Is there any reason why Congress would put this language in here is there any other case law in this language or?
Not to my knowledge, Your Honor, I'm sorry.
It's okay.
Well, I mean, if we do want to turn perhaps to the merits, I mean, the RFRA claim maybe there's two different kinds of RFRA claims or two different aspects. I mean, they have their individual claims about whether in their particular circumstances a vaccination, COVID shot is the least restrictive means to advance a compelling interest. But then, as you know from our other case, I mean, we have this, and maybe it's frankly, as I'm thinking about, maybe it's a question for the other case, but there is this RFRA claim that is based on the idea that RFRA itself requires the government to perform, to make an individualized determination of those same things I just talked about before imposing this burden on an individual, as opposed to the government just saying, nobody can engage in certain kinds of conduct that might affect a religious practice, where everyone has to get vaccinated. And if any believers are unhappy, they can come out of the woodwork and we'll deal with that in court. I mean, those are two quite different regimes. And so, I mean, why is it unreasonable to read RFRA to apply to the government in the first instance the same rule that we apply in court, namely strict scrutiny, and you're supposed to perform that analysis before somebody has to go through what they've been going through, as opposed to we just do that later? Why? I mean, I get the sense that the government disagrees with that sense of, that RFRA is unconcerned about neutrality is one way to put it. And so why is it that you think RFRA does not ban sort of group-wide discrimination, and it's only for those individuals who, where the government would fail strict scrutiny, that there's a RFRA violation? I'm sorry for the long question, but it's kind of involved.
Yeah, absolutely. I think there is a lot to unpack there, Your Honor. I will start with I don't read plaintiff's complaint or their motion for preliminary injunction to be requesting the kind of process-based relief that you're contemplating. So that's the sort of threshold point, that I actually don't think they've raised that claim in this case.
But is it possible it can be encompassed as a lesser remedy within that broader remedy that they're asking for?
Perhaps. That's not the relief the district court granted. The district court granted, so far as I understand, individualized accommodations for each of the named plaintiffs and then for the some 10,000 service members in the class. So those individualized accommodations, so far as I understand, is what the district court has required the Air Force to take in this case. Moreover, the text of RFRA itself requires that the government demonstrate to the person in court why it has a compelling interest.
Why do you think it would be such an odd statute? Do we say that Title VII bans race discrimination, or do we say that Title VII allows you to engage in race discrimination, but gives the plaintiff, the victim, a right of action in court? I think everybody would agree that it's designed to influence conduct, not just to give a cause of action on the back end. And when I read RFRA, I don't read anything that looks different. It says, the way I understand the text is it says it's a categorical command. Government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, except as provided in if you can prove a compelling interest. That strikes me as an obligation on government, just like Title VII is an obligation on private employers. Why is this statute different?
So I think, for one, I apologize, I don't have the provision in front of me, but in Title VII prohibits certain types of employment practices and lists quite a number of the different kinds of employment practices that are prohibited by that statute and affords a cause of action to vindicate those violations. No similar requirement is in RFRA. Moreover,
It's a shall, government shall not substantially burden a person's exercise of religion. Strikes me, it's a requirement.
that's something that a court can adjudicate, but it is not something that requires the government to determine.
Yeah, it has, just like Title VII has a cause of action for violations, but the entire point of this statute is that we don't want to have to get to court because we expect the government to follow the law.
Right, but I believe in most Title VII instances, Your Honor, first the claim has to be presented before the EEOC and before it can come to federal court. Moreover, if to the extent you think that...
But is it the executive branch's position that you don't have to worry about RFRA until somebody sues?
More or less, yes. Like, RFRA itself is not a record review statute and does not require the government to take any particular process. If I object...
Well, I mean, it's not that RFRA is mandating a process. It's saying you can't do certain things unless you can't burden faith unless certain circumstances, i.e. compelling interest, least restrictive means, are present.
And that's something for the court to adjudicate.
Not really. I mean, I'm not aware of any rule of conduct, any law, where the law as it exists governing the person's conduct before court is somehow different from the law that we apply to them when they're in court. That would seem to be a due process violation in some cases.
So it is worth noting that if this is the court's view of RFRA, then the plaintiff's claims haven't been exhausted. And you wouldn't be able to adjudicate them now without giving the military the opportunity to do so in the first instance. Moreover,
I think we're miscommunicating a little bit. I mean, read literally, the language that Judge Murphy just read says the government can't do this, cannot impose the burden until or unless, right? You make this showing in court. So if we're going to be literalist, which is different than the way we normally read, it's not textual, literalism's different, sure. But if we're going to be literalist, you literally cannot impose the burden on them before you come get permission, I guess, in court, right?
I don't think it's that the court gives permission.
Well, but until a court makes the determination, until you make that showing in court.
I disagree, Your Honor, and I think that RFRA allows...
Wow. I mean, but the government, I think, is being quite literal in its reading of RFRA to say our obligation is only to make a certain showing in court. And absent that, we can do whatever we want. We can impose whatever burden we want. And if somebody doesn't like it, they can make us go through our proofs in court. That's kind of what you're saying, right? But unlike Title VII, where you can't do it in the world either.
I think it's the same, Your Honor. Title VII prohibits certain types of discrimination in employment offices, just as RFRA prohibits discrimination against religion. But there are separate exhaustion requirements in Title VII that don't apply to RFRA. And you could vindicate each of those rights by coming to federal court. And it's not that the statute provides some kind of ex ante protection before a federal court adjudicates your claims. Rather, if you, for example, feel burdened by a particular policy, you come to federal court and sue challenging that policy. Then the government has the opportunity to explain why there's a compelling interest and why no less restrictive means could accomplish the same ends. I apologize. I know we.
No, you don't have to apologize because you've just been answering our questions. But I think this one, perhaps I should have waited until the class, argument. But any further questions before we hear from Plaintiffs' Counsel? All right, thank you. You'll have your full rebuttal.
Thank you very much.
Good afternoon, Your Honors. My name is Chris Wiest. I represent the plaintiffs today along with Mr. Bruns, Mr. Seery, and Ms. Cox. I wanted to begin my argument this afternoon by observing the standard of review, which is something you did not hear counsel for the government mention. This court, I think, appropriately summarized it in the Dahl case, Dahl versus Board of Trustees of Western Michigan University, in which it said that the review here is, quote, highly deferential, that the findings of fact must be, quote, clearly erroneous. And in conducting that clearly erroneous factual review, this court observed that the finding must, quote, strike us as wrong with the force of 5-week-old unrefrigerated dead fish. Your Honors, when you look at the findings of the district court in this action, none of them are clearly erroneous.
There's an awful lot of law in this appeal.
There is an awful lot of
This
law.
isn't just some fact-finding exercise here.
Your Honor, no doubt. There is an awful lot of law, and I think we're happy to address all of that law and all of the government's arguments.
On justiciability, I mean, the one thing I wanted to ask you about is, with respect to Article III ripeness, why doesn't the government have a point as to plaintiffs who have not gotten a definitive answer with respect to their exemption request itself? So I'm not talking about starting separation, but just, what kind of a final yes or no about the exemption.
If I understand the court's question, it is getting the adjudication, at least through the initial decision maker and perhaps on the appeal from the Surgeon General.
I guess when it's over, there's a point where that request is finally denied as far as the Air Force is concerned. And then consequences, I suppose, start to follow. And why isn't that point, when after final denial, why isn't that the point at which it's right?
For several reasons, Your Honor. And let me begin here. Ripeness is tied in fundamentally with the question of standing. And Judge Sutton made that point in Winter versus Wolnick, 834 F. 3rd, 681, 687, where he indicated, quote, the line between Article III standing and ripeness in pre-enforcement First Amendment challenges has evaporated. And then if you turn to this court's articulations in Parsons versus U.S. Department of Justice, 801 F. 3rd, 701, 710, this court says only one plaintiff needs to have that standing. Below, the government conceded that two of these plaintiffs were both ripe and justiciable.
That's for us to reach it, but, this is the individual PI appeal.
Right.
And these plaintiffs are getting relief individually. And the government is saying some of them don't have Article III standing for ripeness reasons to get that relief yet.
And
So that somebody else has a ripe claim doesn't answer the question whether another plaintiff is entitled to injunctive relief when her claim isn't ripe, in their view. I'm just giving you a chance to explain why it is ripe.
Right, and several reasons in response to that. First of all, we believe only one plaintiff needs to establish ripeness, but putting that aside, all of these plaintiffs' claims are ripe. And if you look at this court's test in Berry versus Schmidt, as well as the district court's findings, the first question is, what's the likelihood the harm would ever come to pass? Well, Your Honors, as you noted just a few weeks ago, there are 0 standalone exemptions. Every single one of these plaintiffs are going to have, if they've not already had, their accommodation requests denied. None of them are in the class of individuals, the very, very few, I think it was 100-something, that are at the end of the term of service. None of them are. And the record below supports that. Lieutenant Doster testified that none of them were in that circumstance. That factual finding was made by the district court. It's not clearly erroneous. So there is a 100% certainty.
You're arguing futility then, basically, is your argument.
In part, although I would say that the harm is ever present. And if you look at the constitutional harm that's present in this case, the coercive effect that this court recognized in Dahl, in terms of the coercion of religious freedom and free exercise, that's occurring immediately. There is no doubt there are all kinds of statements of threats from the Secretary of the Air Force all the way down, including the government's own proof in this matter, all of which fundamentally establishes that there is no doubt that the harm is going to come to pass in this case. Your Honor.
Can I ask just a factual clarification question? You said in your brief that 14 of the 18 plaintiffs had received a final rejection of their appeal from the Surgeon General of the Air Force. And I looked through the record. I could only find 10 of those letters. I'm just curious if you know the status of the 18 plaintiffs. Are there, has everybody, who's left who hasn't had a rejection yet?
Your Honor, I would want to go back and talk to my colleagues on this, but I believe Colonel Anderson, I think there was a couple of others, but the number is 4 that have not had final adjudications through the.
Well, you said 14, but I could only find 10 letters in the record, so it might be worth clarifying on the scope of what this issue is about, actually.
Right. And I think the 14 that we indicated, I'm not sure, there were some supplemental filings that occurred in this case in which we were updating. Obviously, these denials were coming in after the fact, including in some cases after the preliminary injunction was issued, that were of record below. And if it's not complete, obviously we have those denial letters. I don't know, I'll need to check with my colleagues. I think all of that was put of record. There may have been a couple that we did not put of record. 14 have had their final denials, though. And for the other 4, again, there's no doubt that there's going to be a denial for them on this record. There's no indication that that's not the case. And again, the likelihood is substantial. I mean, if you look at even the raw percentages, there's a 99% chance of a denial just on the numbers themselves. That's a highly likely chance that the harm's going to come to pass under the first Berry prong.
I don't want to hijack your argument, Tom.
Yes, Your Honor.
This, okay, it was just like one sort of discrete question. So if there are other things you want to talk about, feel free.
Absolutely, and I'm happy to finish the ripeness and then the justiciability issues. But again,
If we turn to justiciability, so RFRA creates a statutory cause of action. Maybe there's good arguments that no judge-made tests should apply in that context, but I assume your First Amendment claim is under the judge-made cause of action, just ex parte Young, you seek an injunction to enjoin what you think is unconstitutional conduct. Now that is, as far as I can tell, I mean, ex parte Young is quite complicated, but it is a judge-made cause of action. Maybe there's more room there to impose judge-made limits on the cause of action if we think they're appropriate in our prudence. So query, why don't you talk about that? Why shouldn't we do that for the First Amendment claim?
Your Honor, because they are part and parcel and tied up fundamentally with the RFRA claim itself. And I think the courts that have addressed this, and there are several, have all found that, first of all, RFRA has no exhaustion doctrine. The Fifth Circuit found it in the Navy SEALs case, the D.C. District Court, which deals with, frankly, a great number of these military cases, found it in the Singh case, and we also saw it by the Ninth Circuit and I'm never going to get this pronunciation right, Oklaahoma Native American Church of Hawaii, Inc. versus Holder, which also found no exhaustion requirement in RFRA. And that comports, by the way, with the plain language text of 42 U.S.C. 2000 BB-1C. Briefly, Your Honors, if you look at the purpose of RFRA and you look at the congressional discussion of it at 42 U.S.C. 2000 BB-B1, Congress indicated that there were actually 2 purposes under which it enacted RFRA. First, to restore the compelling interest test after Smith, and secondly, to provide a claim or defense. And that claim or defense, by the way, arises, and we would submit as both ripe and justiciable at the point that it arises, when a person whose religious belief has been burdened, when that occurs. And the instance of that occurring is what gives rise to the cause of action and the entry of, quote, appropriate relief.
It's not, RFRA is not 1983. The entire point of RFRA was to expand beyond what the Constitution required. It's a statutory right. It's not a constitutional right.
That's correct.
So I don't think you could cite RFRA as the basis of enforcing any claim directly under the First Amendment.
I think, Your Honor, if this were a standalone claim without without the second count, without RFRA, then in analyzing it that way, you would be correct. And obviously, we would get into some of the issues that sometimes get into some of the judge-made doctrines in that regard.
If we were to determine you had a RFRA claim here, is there any reason to get to the constitutional claim? Is there any remedy that you're going to get under the Constitution that you wouldn't get under RFRA?
I don't believe there would be here, Your Honor. In fact, I think RFRA is probably going to provide more relief. But obviously, the fact that we're dealing with a constitutional right also, if you want to apply Harkness and Mendez and justiciability, that's one of the factors, right? What kind of claim is it? Are you alleging some regulation violation, or one of the first Mendez prongs is what's the nature of the claim? And here it's a constitutional.
Before we leave the First Amendment, what would, on the merits, so setting aside the cause of action, why wouldn't we be bound by Goldman? So Goldman is a case that said the government, it was a case, a service member wanted to wear a yarmulke, and government, military regulations prohibited it. And the Supreme Court said that even pre-Smith, so this is pre-Smith world, Sherbert does not apply in the military context. So why wouldn't that rule still be applicable even if the government engages in discrimination, it might avoid Smith, but why wouldn't it go headlong into Goldman, which essentially applied a rational basis test under the First Amendment?
So, Your Honor, one of the things that was going on in Goldman was a neutral and generally applicable regulation, and that was one of the points that the Supreme Court made in Goldman, that it applied equally to everyone. Obviously, here, we're dealing with a discriminatory policy under the plain language of Fulton. We're dealing with an exception by exception administrative and medical exemptions. We're dealing with Tandon that talks about comparable interests. We're talking about blanket exemptions being granted to pregnant members, to end-of-service personnel, all of which take this outside of neutral.
I was curious, but the Goldman did have some exceptions. So they had jewelry exceptions that the court mentioned in the opinion itself. I thought that might be your response, and so I guess the counter on the other side would be, well, under the court's kind of vigorous view of looking for exceptions today, I'm not certain that Goldman would qualify as neutral and generally applicable given the exceptions for wearing jewelry and certain hairstyles.
Well, and certainly, Your Honor, the case law involving what's neutrally and generally applicable has moved substantially since Goldman was decided. We did not have then the benefit, for instance, of even, and I'm never going to get this pronunciation right, the Church of the Leukemia Bi. We did not have Smith talking about neutral and generally applicable. We did not have the development of the case law in Fulton or Tandon. Certainly, our understanding of what free exercise means today is fundamentally different than when Goldman was decided, and on that basis, it is distinguishable. I think one of the things that I wanted to mention too about Goldman is, and this just gets into some history of RFRA. Goldman was actually he ended up becoming a rabbi after his time in the service. And he was one of the people that was pushing for the enactment of RFRA. And with all due respect, Goldman would not have any bearing with respect to the RFRA claim. That's a statutory cause of action, but you would be correct that it could have some bearing on the First Amendment. Our understanding of the First Amendment has obviously evolved. This case is on four with Fulton. This case is on four with Tandon. And it's not on all fours with Goldman. The only exception to the headwear that was going on in Goldman were for particular militarized interests, specifically, I believe it was like the security forces that were under arms, that had a purpose for keeping that headgear on, so they weren't fumbling with a weapon to go in and out of a door.
So I was curious. This is so when Congress passed RFRA, the government cites this tidbit of legislative history that suggests, in citing Goldman, that historically, the court has given deference to the military. The courts have under the Constitution, and we expect deference to continue. Now, it's just legislative history, but then in Cutter, the court said the same thing with respect to prison administrators. And so it seems to me that strict scrutiny, generally speaking, is a very compelling test, and there's no such thing as deferential strict scrutiny. But now, Cutter at least suggests that we're supposed to at least give some deference, because that's what we historically have done to the military. So how do you reconcile the fact that it is a Sherbert test, but that Congress seems to, and Cutter seems to anticipate that we're supposed to give deference under that test?
Your Honor, one of the things that Congress talks about deference is just simply whether or not something is in fact a compelling interest. In other words, there was the sonar interest in training in winter versus NRDC. The degree of deference for the government to prevail here, though, would have to arise to more deference than was even provided in Holt versus Hobbs, in which the Supreme Court, in a prison context, indicated that it was not going to permit a, quote, degree of deference that was tantamount to unquestioning acceptance. That would be what you would have to get to here to provide them enough deference to prevail. And the reason is simply, again, the discriminatory nature of the robust granting of secular exceptions, which they seem to have no problem with, that they grant in the thousands, while simultaneously discriminating against religious exemptions. And I would note, Your Honors, one of the things that goes on with the government is its processing. And this is also of record, there's no question about this. If you go in and you get a medical exemption, you go in to see the doctor confirms you have the condition. It might even be a condition that is not going to be undermined with respect to a COVID vaccine, for instance, pregnancy. The CDC says there's no reason not to vaccinate pregnant people. And so you're not undermining any kind of medical interest there. The government grants it with the doctor confirming it, and that's the end of it. Now take the religious processing that they engage in. They go, you confirm, just like with the doctor, that you have a sincerely held religious belief. You do that with the chaplain. He confirms it. He also happens to confirm in his memorandum that it's substantially burdened. Now, if it were equal processing, that would be the end of it, but that's not what they do. Instead, there's this entire iterative process under which they try and figure out if they can quote-unquote accommodate you, and as we've seen, the result of that process is a over 99% denial rate. So the discrimination begins from the outset. From the very first step, it's discriminatory in terms of what they do with the medical exemptions and the secular exemptions and what they do with the religious exemptions. And when you look at the degree of deference that they're asking for, it's undermined by the language of Holt. That's a prison context. One would think, I don't know, one would think that a prisoner who has committed a crime, who has been adjudicated a criminal, would have less rights in the religious freedom context than the people that have sworn an oath to uphold and defend the Constitution. And by the way, if you look, Your Honors, at the House Report number 10388, this is another congressional piece of legislative history. Even Congress is saying in the military context, quote, seemingly reasonable regulations that are based on, quote, speculation, quote, exaggerated fears, or, quote, thoughtless policies cannot stand. The District Court of D.C. indicated that this deference that they're arguing for is not appropriate in Singh versus McHugh. And there was one more recent case that we would point to for this to refute their arguments about deference. There was a case from earlier this year from the United States Supreme Court, Ramirez versus Collier. And that, of course, was a case that dealt with whether or not a pastor could lay hands on someone who was in the process of being executed by the state of Texas. And in that case, the Supreme Court, and I'm going to quote from them, indicated that, quote, Texas asks the court to defer to its execution chamber policy determinations, but RLUIPA requires more when a policy imposes a substantial burden on sincere religious exercise. Further, no basis for deference exists given the state's history of allowing prison chaplains to audibly pray with the condemned during executions. One would think, Your Honor, that if anywhere a government is going to get deference, it's in the execution chamber and the carrying out of that process. And yet there, the Supreme Court said no, and in part the Supreme Court said no because the state itself had allowed the activities to occur, you know, in other contexts.
I think, what's the status of the vast majority of the religious objections have been abortion-based and the facilitation of abortion with the making or of the drugs or testing of the drugs. What's the status of the few other vaccines that apparently are not available in the United States but would not have this connection that many find problematic?
And Your Honor, it's interesting. One of the arguments the government has made is that somehow that this injunction prevents, you know, the military operations. There were two of the plaintiffs in this case, two of the original 18, who were told under the exception for assignments and operational considerations that they were going to have their pilot slots pulled, Lieutenants McCormick and Ramsberger. And what they ended up, actually Lieutenants Martin and Ramsberger, and they ended up traveling to Mexico dangerously in getting a product that doesn't have those connections. It's known as Covaxin. Our understanding is that that product, at least current understanding, has no connections to the abortion process.
What if the government facilitated the obtaining of these vaccines? Would that be at least a restrictive means? It would seem the government is satisfied with these vaccines. Two of the plaintiffs have obtained them. If the government facilitated obtaining these other vaccines, would that satisfy, even if suppose, I know some of the plaintiffs don't want to take the vaccines for reasons unrelated to religion, which seem perfectly legitimate. The FDA has not approved them. But that would not be a religious-based objection. That would be a kind of a medical-based objection. So if the government made these vaccines available, would that be a lesser restrictive means?
Your Honor, the government obviously could not compel those under other statutes, and they would be untested, unapproved by our own government. The government is obviously not.
But the government is, the military is fine if you take the vaccine, that satisfies the criterion. So they wouldn't be, so you would still consider it compulsion, I suppose, if they say this is the lesser restrictive means?
I think it's problematic and it's an equal burden on religion to say you have to take an untested, unapproved product that our FDA is not willing to put its stamp on, although it is under clinical trials in the United States, that product is, and to say that, we're not even going to license it for emergency use, and that's the alternative, you need to do that. Now here, two of these gentlemen, I don't know that it's repeatable the extraordinary means that they had to go to get it, potentially in a back alley in Mexico. But putting that aside, from a purely religious perspective, for the people that have only objections to aborted fetal tissue, obviously two of these folks had that objection, and two of these folks received this particular vaccine, and they were willing to do so consistent with their sincerely held religious beliefs. That said, I don't think it is a least restrictive means for the government to sit there and say, we're going to go and break other aspects of federal law to accommodate you. I suppose they could.
How can it, if it breaks federal law, how can they have it as a approved option?
That's a great question, Your Honor. They can't mandate it and they can't offer it in the United States, but apparently if you want to go and get it on your own overseas, then they've allowed that as an alternative option. And I don't know, I don't believe that would necessarily break federal law, but they can't import it and offer it in the United States to these folks consistent with federal law, which is why, it is fiction to suggest that it's a real alternative here.
On the deference question, just to try to understand like the bounds of potential deference, at least as applied in this case, I mean, do you agree, I would think, and tell me if you don't, that the Air Force has a compelling interest in having a healthy force of air people or airmen, and that they have a compelling interest in people being ready, able to deploy on short notice, et cetera. You agree with those compelling interests?
We agree that those on a very generalized basis
Right.
are
Very
compelling interests. They're obviously not going to be compelling in the context of being able to intrude on First Amendment and RFRA because of the requirement for more specificity that the Supreme Court has.
No, I get that. But as far at that level of generality, you don't have any quarrel with their compelling interest, the ones that they're asserting.
As a general compelling interest, we don't believe that they're sufficient to intrude on First Amendment rights. They don't rise to the specificity, particularly, they're right.
No, yeah, I get it. And then, so it's as to least restrictive means that you would, I think, you tell me, how do you feel about deference in that area?
Your Honor, there is no way that they can possibly satisfy least restrictive means when they are allowing robust numbers of secular exceptions. They cannot do it. If this were a blanket, no exception policy, I think it'd be a tougher case, frankly. That isn't this case.
What about their argument that, and this is something they emphasize much more in their briefing for this appeal as opposed to the stay motion, that these exemptions are different in kind because the religious one is permanent, whereas the other ones are temporary.
Well, Your Honor, that's simply not true, and I know that they've taken that position at length, and we filed a 28J letter in part yesterday to deal with that. What the regulations say, both the Department of Defense regulations and the Air Force instructions say, are that yes, you can get these religious exemptions, but they're subject to ongoing review. And if circumstances change and the government makes the same showing it's initially required to make under RFRA, then they can, at any point in time, pull them back. And so this suggestion that somehow these are quote-unquote permanent simply isn't true. Now, we expect, just as a matter of fact, the majority of these 18, when the government approves the Covaxin product, to receive the vaccine. And in that sense, we are dealing with a temporary exemption in the same way, by the way, as to the majority, but yes.
It's still different than the admin exemption, right? Because isn't the admin exemption predicated on just 6 months and you're discharged?
Well, that's one admin exemption. The other admin exemption that they have is the vaccine placebo, right? And so if you go and you're part of a vaccine study and you get the placebo, you get an administrative exemption for that as well.
But aren't anybody who gets the admin exemption, is there a presumption that they're non-deployable? Or is it folks that are going to not be deployable in those 6 months, and so they're distinct from the plaintiffs?
So, Your Honors, there's two levels of waiver. Obviously, there's the exemption itself, and then there's another level of waiver for deployability. And this was also in the Department of Defense instruction that we filed in the 28J. I think it was 649007, and so you can get a MAGCOM commander essentially to waive the deployment, and that occurs not infrequently. We also think that that same waiver to policy raises the same issues under Fulton because it's available and all. It doesn't even matter that they're granting them. The fact that it's there suggests that you cannot, rely on that. The government cannot rely on that to say that these are somehow different. The reality is they're waivable, and there's exceptions to them.
You want to wrap up for 60 seconds on this one?
Your Honor, I'm happy to. Just briefly, we believe, not that we believe, the district court's findings were all supported with factual evidence of record. The district court appropriately applied the circuit's case law, and its injunction for these 18 plaintiffs should be affirmed. Thank you, Your
Thank
Honors.
you. We'll hear from Mr. Ross. And Mr. Ross, one thing I wanted to ask you, just to sort of identify what's contested here and what isn't.
Sure.
As you know, the plaintiffs have argued throughout the litigation, at least in this court, that the Air Force has not granted any standalone religious exemptions, meaning exemptions to people who were not eligible for some other exemption as well. You know what I'm saying?
Yes.
Right.
I just want to make sure that I want to be very clear.
In other words, the numbers that the government has been citing, like 138, or, they obviously change, but that they have argued that in each of those instances, the person was separately eligible for an administrative exemption, I think was most of them, or maybe a medical. And we pointed that out in our opinion on the stay motion and said it appears that the government's not disputing this. And so, for purposes of our decision, the number is actually 0. Now, having read the government's briefing in both appeals, I thought the government sort of pointedly omitted to dispute that same point. And so I want to, am I overlooking something in the briefing? Has the government actually disputed that, is the government asserting that some of these were standalone religious exemptions as opposed to just people who had another reason to get an exemption anyway?
Yes. Sorry, I just want to be very clear. Yeah. There are service members who have been granted religious exemptions who would not be eligible for administrative or medical exemptions.
Okay, and so, do you have anything for us to back that up?
It's not in the record, Your Honor, and the service members who have been granted those religious...
How come the government doesn't say that in any of its briefing? This issue was highlighted before these briefs were submitted, and the government just doesn't take this on.
Mostly because, frankly, Your Honor, it's just not in the record here. And if anything, it shouldn't bear on the disposition of this appeal because, for the reasons we've stated in the briefs, the basis for the different kinds of exemptions are fundamentally different. I will emphasize pointing to...
But the point is, the government has been saying, hey, we granted 138 of these, and so, among other things, a person should have to go all the way through the process before their claim is ripe. Well, if all 138 were granted to people who were within 6 months of leaving the service anyway, then that rather takes the wind out of the government's sails in saying we're granting some of these. We're granting some as long as you're eligible for another one, is their argument.
So two responses, Your Honor. One, I apologize for the lack of clarity in the briefing, but again, this just isn't in the record, and there aren't publicly available sources that we can point to because these are, individual circumstances that are sensitive.
So you did have one sentence in the reply where you said, the Air Force has now granted over 130 religious exemptions which have been not granted to service members who would qualify for an administrative exemption.
Exactly.
But have been granted under similar circumstances. So is this something like the admin exemption requires 6 months and it was 6 months and 2 days and therefore you granted a religious exemption? Is that what the clause, but have been granted under similar circumstances, was trying to convey?
It's within a year. So there is a delta between administrative and religious exemptions. Okay. And I think that's meaningful. But also, the fact that religious exemptions are treated the same as administrative exemptions is also meaningful.
So why don't you treat, so you treat religious exemptions, the government, the Air Force, treats religious exemptions as permanent. But the government doesn't treat medical exemptions as temporary. So imagine a hypothetical where.
It does treat it as
or
temporary.
medical exemptions as temporary,
Yeah.
correct. And what if somebody has an allergy to all the current vaccines, but wouldn't have an allergy to one of the new vaccines that the plaintiffs wouldn't object to taking? So once those vaccines get approved by the FDA, the person with the allergy to all the other vaccines can take this. So that's temporary. Why is that person not exactly similarly situated to a plaintiff who would also be willing to take that vaccine?
The first reason is that if the person with an allergy takes the vaccine, they would be harmed by the existing vaccine, they would be harmed by taking it. And so the military grants the exemption on that basis.
But the entire point of RFRA is that we're supposed to treat a religious objection as almost analogous to a medical objection.
But the government's interest in treating them differently it could not be more different, because the reason for, in fact, the government's compelling interest in denying religious exemptions runs in the same direction for Your Honor's hypothetical of granting an exemption for a service member with an allergy.
But why would it, okay, so the interest is different, but why is one temporary and one permanent?
So it is, I will point the court to DOD Instruction 1332.45, which requires that all service members be deployable for 12 months consecutively, and if they're not, they're subject to a retention decision. So apologies to fight the hypothetical, but if there's not a vaccine that's approved that would not, or that would still contraindicate the service member's allergy, they would be evaluated for separation from the service.
But why wouldn't you treat the individual with a religious objection the same way and say, okay, we'll give you 12 months and then we'll reassess things, and then within that time, maybe a new vaccine came out?
Well, so for one, none of the service members here have actually requested that. So record entry 11 is the relevant materials for their letters requesting exemptions. I believe they're all permanent. And so, yes, maybe they assert in their briefing now that the exemptions are temporary, but that's not what they said to the Air Force.
They said in the PI. It was in the PI hearing. I think all three of the individuals who testified in the PI hearing that they would be willing to take a vaccine that was FDA approved and didn't have the connections.
And on August 19th, the Novavax vaccine was given an emergency use authorization and is not connected to fetal stem cells. And two of the plaintiffs have since been vaccinated, or excuse me, two of the plaintiffs testified that they would be amenable to taking that vaccine, but have not.
Well, I mean, that's beyond the ken of.
Absolutely. I'm merely offering it for the court's consideration. I will turn to the merits because we've had quite a lot of discussion about the threshold issues. But plaintiffs effectively admit that with respect to these named plaintiffs, that there is a compelling interest in ensuring that they're vaccinated. And there is no less restrictive means.
Well, they don't admit that. They admit at some level of generality, you know, the government has a compelling interest in a healthy force. I don't think they're admitting anything really as to them.
But the important question here, Judge Kethledge, is the district court never considered this question.
But why, isn't it your burden?
Yeah,
So I was
that's what
curious.
I was going to get into.
I was curious who, at first I thought it was the plaintiffs that should tell us kind of what their job duties are. But then when I realized that the government bears the burden of proof to demonstrate a substantial interest, or the Sherbert test, with respect to each individual plaintiff, with respect to each individual circumstance, shouldn't we, it's astonishing to me that I read the government's brief and I have no idea from just reading the government's opening brief alone what any of the plaintiffs does. And as I understand Ocentro and Hobby Lobby, we're supposed to be asking, does the government have a compelling interest in forcing this individual who engages in these duties and has these circumstances to take this vaccine? And the government is just at the highest level of generality that Ocentro and Hobby Lobby say is insufficient.
So part of the problem with that, Your Honor, is that this case was prematurely adjudicated. At the time the government filed its opposition to the preliminary injunction, we were able to provide declarations from only 5 of the plaintiffs' commanders to testify as to why it was necessary to have them vaccinated, describing their duties and whatnot. And we cite all of those declarations in both the opening brief and the reply brief. And I can get into them in detail if that would be helpful.
They seem to be rather boilerplate.
I disagree, Your Honor, because each of the declarations Lieutenant Colonel Polier's, Colonel Wren's, Colonel Reese's, all explain in detail those particular service members' obligations and why they might be called to deploy on 72 hours notice, for example, or why other means would not sufficiently accomplish the government's interests for having those plaintiffs be deployed. And these are the kinds of military interests that fall in the heartland of those military officials' can of expertise.
Yeah,
And-
but I mean, there's a whole level of analysis that we really haven't even gotten into as to least restrictive means. You know, somebody who's had COVID twice, hypothetically, whether a shot for that person is the least restrictive means to meet some of these goals. And I mean, anyway, yeah.
So I will point you to Colonel Pohl's declaration, Your Honor, which
yeah.
systematically goes through each of these ostensibly less restrictive means, which will not satisfy the same
Yeah, but,
concerns.
I mean-
And I can say with respect.
Query whether his declaration is going to answer the question in each plaintiff's. There's a compelling interest, and the vaccination is the least restrictive means. And frankly, the government's brief just doesn't even address that. There's a couple of for examples in the reply brief. But, I mean, if we're deciding to adjudicate the RFRA claim, I mean, the government has almost forfeited any individualized analysis, which the government says is necessary now that we're in court. The government's basically forfeited that unless I'm missing something.
Respectfully, Your Honor, part of the government's brief was, certainly the opening brief was taking issue with the analysis done by the district court. And the district court never performed exactly what you are saying. That is, it never considered any of the 5 declarations that I just listed provided by plaintiffs' commanders and didn't consider whether, at least in those specific circumstances, that the government satisfied its burden or not. We don't know the answer to that question.
We review judgments, we review orders. We don't really grade homework that much. And the question here is just whether these folks are substantively entitled to the injunctive relief that they got or not. It's not whether the district court skipped a step here or there. And it's been the government's burden all along, and I'm just kind of scratching my head. I mean, as Judge Murphy said, really nothing in the blue brief. The blue brief is like most of the chips are on justiciability. In the reply brief, and it was fair in the reply because they get into it in the red brief, but the reply brief just really doesn't engage in this directly. It's just sort of a couple, literally, for example, 2 or 3 people. How can we vacate this award of relief to these individuals if we reach the merits when the government hasn't made the effort to show what the government says RFRA requires you to show?
So I think that there are actually a lot of declarations in the record, Your Honor, substantiating.
But it's not our job to go sift through those.
No, absolutely
sort
not.
that out. I believe you have to kind of make an argument that here's the compelling interest, here's the least restrictive means, here's why they're wrong in saying we haven't met that.
And I just respectfully disagree that the government didn't do so. We cited declarations from Lieutenant General Schneider.
Do you think the job duties, are the job duties completely irrelevant of any of the plaintiffs?
No, and I can discuss any of them.
Why would you not tell us what the job duties are? Like, I know what a lot of the job duties are, but it's from reviewing the evidence.
Mm-hmm.
I would think that the job duties go into whether masking or social distancing or other things are narrowly tailored, unless you're saying, and this gets into the next case a little bit, but unless you're saying these generalized interests are perfectly fine for every conceivable Air Force member.
So we did attempt to do that in the reply, in contesting, the general assertions in plaintiff's response brief. Part of the problem in this particular case, and this also bleeds into the next case as well, is that there are 18 named plaintiffs, and given the constraints on word limits for briefs, we are trying to respond to the district court's reasoning at an appropriate level of generality to explain why that analysis was wrong. And we made every effort to do that, and I apologize if you are disappointed.
We're not trying to
disappointed,
but either, all right? But, I mean, when it boils down to it, do we have an adequate basis to rule one way or another? So that's okay. Any further questions for this? You can have 60 seconds to wrap up if you'd like, and then we'll move on to the next case, I guess.
Sure. We haven't discussed irreparable injury at all, but I will just underscore that.
We did at the beginning.
Oh, I suppose that's true. Sorry, it's been a while. I will just reiterate that the district court abused its discretion in granting relief to these 18 named plaintiffs. To the extent this court believes that any single one of them should have been granted or not been granted a preliminary injunction, and the Air Force could enforce the vaccination requirement against any single one of them, then it need vacate the preliminary injunction with respect to all of them for more appropriately tailored relief.
All right, very well. Thank you both for your arguments in this appeal. Do any of you need to take a 5 or 10 minute break before we get into the next appeal? I mean, it's harder for you all than it is for us. You want to take 10 minutes? Or do you want to just keep going? I defer to the two arguing lawyers.
5 minutes?
5? You want to take 5?
That's okay.
Okay, 5 minutes. We'll be back in 5.
This honorable court now stands in recess.
By the time I was a senior, I never had to do that. It was always my whole time in the nights. I was on flights.
Hey there.
It's all under control.
I think so.
Looks like you do. Crowd trying to get in.
Oh, the taps.
I didn't know her back then.
All rise. This honorable court is now in session. Please be seated.
All right, you can call the second case. You're fine where you are, Mr. Ross.
223702, Hunter Doster et al. Versus Frank Kendall et al. Arguments not to exceed 20 minutes. Mr. Ross for appellants.
Okay,
Thank you again, Your Honors.
sure.
Caseman Ross for the United States.
Yep.
The district court, in granting a class-wide preliminary injunction, failed to fulfill its judicial role, compounding the errors flowing from the initial injunction granted to the named plaintiffs. On the merits, the district court never performed the individualized inquiry that RFRA requires, essentially determining that nearly 10,000 service members are entitled to relief under that statute without considering any single one of their circumstances, and effectively overruling a number of other courts who reached the contrary conclusion, including the Supreme Court.
I mean, we do start from the common foundation of the stay litigation, and you know what the three of us said about that, which is that that's not the claim the court certified, right? And that, so now we can talk kind of directly about this claim of it's a discriminatory policy. It's a categorical, de facto categorical ban, or at least a strong bias against requests for religious exemptions. And so the RFRA claim that the court certified, I mean, we agreed in the stay opinion that you can't certify the individualized analyses claims, across 10,000 people, obviously. But their claim is the Air Force basically denies all of these, and it's a discriminatory policy. It's like a pattern and practice under Title VII, and it's a class-wide treatment, and class-wide relief is appropriate. So that's how we left things in our last exchange.
Sure. I think there's a number of things to unpack there, Your Honor. First, that's not the relief the district court granted, which was individualized accommodations for each service member. And that is what RFRA would otherwise entitle them to, because under RFRA, there's no process-based remedy.
I don't follow that. I mean, I just recall the district court, the relief, the injunction was you can't fire these folks.
I think I don't want to put words in your mouth, Judge Kethledge, but I think if the district court found that there was a discriminatory policy, and I will say emphatically, there is no such policy.
No, you disagree with that.
Of course. But if that's what the district court determined, then it would grant some kind of relief akin to requiring a do-over, that the Air Force would need to essentially, as you said, root out the policy and do it again. But that's not what the district court required.
Isn't that for permanent? This is just a preliminary injunction. So the preliminary injunction is designed to keep the status quo until the permanent. So I think that if this was a permanent injunction and the outcome was grant the exemptions to everybody, I would agree with you. But the injunction is just status quo. Don't discharge them. Let me consider this, whether this policy or practice exists. At the end of the day, if a policy or practice exists, then the appropriate relief might be the process-based injunction of what you're talking about now.
I don't think so, Your Honor, and because a preliminary injunction of the sort you contemplate would also foreclose the Air Force from continuing to implement this otherwise erstwhile discriminatory policy. So there are a lot of service members, I believe something over 3,000, whose religious exemption requests have not been fully adjudicated. And were it the case that the district court were entering some sort of process-based relief, it would have enjoined the Air Force from continuing this charade.
The PI maintains the status quo while the courts adjudicate the merits about whether there really is a discriminatory policy. And so, I mean, we wouldn't be mandating, cessation of current, consideration of applications that are pending now or anything. It's just it's kind of what the Supreme Court said was okay in the Seals case. Don't fire anybody. Don't bust anyone in rank until we get done with this case, and then we'll go from there.
So I will just note as a procedural matter, in the Navy SEAL case, the government only sought that partial relief. We didn't seek broader relief.
That's what the court said was okay.
Right, but that is exactly the relief we sought, nothing further.
Well, that's the relief they got here too, I mean, right?
And
So it's
in
the
part
same
because they were
relief
bound by
that the Supreme Court said was okay,
Yes.
basically. With some refinements after a couple of orders. Yeah.
I will just say that that's because the government only sought limited relief from the Supreme Court. We didn't seek a full stay of the district court's injunction there.
Well.
Tomato, tomato, perhaps. But more importantly, RFRA doesn't even afford this kind of process-based remedy. If you or I, for example, objected to the Internal Revenue Service's requirement that we pay taxes for religious reasons, then we could just go to court and sue the IRS saying that our religious beliefs are burdened. And then the IRS would respond in kind, et cetera. But there's no requirement from RFRA itself that IRS have any process at all. So too here, the Air Force, as a matter of good practice and policy, has implemented quite an ornate administrative process to fairly and fully adjudicate each service member's religious exemption request.
What if, imagine, I know this is not this case, but imagine a hypothetical that the government interpreted RFRA, the Sherbert test from RFRA, to simply require a rational basis test. And this was an explicit policy, and it said, we think as long as we have a rational basis, we can mandate this vaccine. And it's the policy we are going to be applying to everybody. As long as we have a rational basis in your circumstances, you have to take the vaccine, and RFRA is satisfied. If the plaintiffs ran to court and tried to get a class action injunction against what we would all agree is a misinterpretation of RFRA, it's hard for me to see why that wouldn't be appropriate for class-wide treatment. So I'm just curious if you think it would be, and if it wouldn't be, why isn't the theory that the stay order suggested analogous to that?
I think it's because RFRA doesn't require any particular process, Judge Murphy, that the government doesn't have to have any administrative review at all.
This goes back to what we were arguing in the first argument about how it doesn't really apply to the government until there's a court.
Yes.
Okay, so if we disagree with that.
Respectfully, the Supreme Court said sort of the opposite in Ocentro, where that parties simply sue for an exception in federal court, not before an administrative agency.
Yeah,
And if you just give me one moment, and that's why RFRA is not a record review statute. A number of district courts have expressly held that the record presented in federal court is different from that which is before an administrative agency. That makes a lot of sense here too, because plaintiffs' commanders have submitted declarations where able, because their claims were fully adjudicated in the Air Force, to explain why their exemption requests were denied. And so it makes a lot of sense that the government would make a showing in federal court, as the statute contemplates, that to see whether it can deny an exemption request to a particular policy. And so it's sort of like the Third Circuit's decision in Allen, for example, where the court reversed a class certification of claims challenging accessibility barriers, where the district court certified a quite broad class as violating the Americans with Disabilities Act. But on review, the Third Circuit held that a number of those accessibility barriers don't actually violate the statute, and reversed on that basis. Similarly here, the fact of whatever defect the court believes there is in the Air Force's process is no grounds for relief under RFRA itself. And thus, a class could not be certified on that basis. That's why the Supreme Court explained in Walmart that a certifiable claim has to be apt to drive the resolution of the litigation and be central to the validity of those claims. So without the underlying predicate of a substantive cause of action that could be certified, class certification is improper.
Well, then we have the First Amendment claim. And obviously, leukemia requires neutrality. And their claim as to this discriminatory policy is that it's non-neutral. And if they have significant proof to that effect, then it would seem like under Walmart, they're entitled to the class-wide injunction. So where do you want to go after that?
There's a lot to chew on there, Your Honor. I think first is there is absolutely no evidence in the record of any bias against religion. I think in every...
But, I mean, come on.
Right, no.
99 point whatever % rejection, and that's just, we just close our eyes to that?
No, Your Honor. Sorry. I was merely responding to what I had assumed your question. In Walmart, the Supreme Court explained that a class might be certified on two separate bases, like a policy of actual bias or a de facto policy of discrimination. So I was attacking the one basis that there is no evidence of bias, and I hope the court understands that. And the second is that we do contest that there is significant proof of discrimination here. The statistical evidence plaintiffs have submitted is certainly pales in comparison to what was even presented in Walmart, where the Supreme Court...
Walmart was just a completely different situation because, as I'm sure you recall, the defendant had dispersed decision-making. And so somehow you had to show that the same animating force was resulting in mistreatment of women in Nevada, Connecticut, Florida, and so on. And the statistics just didn't answer that question. It just didn't speak to whether there was some kind of unifying force. I mean, here it's the military, I mean, it's hierarchical by definition. And I don't read the government to be saying here that individual commanders can freewheel and grant these things, and that sticks. To the contrary, at least one plaintiff's commander granted or thought that the exemption should have been granted.
Recommended.
And that person's judgment about the particular circumstances was set aside. So here, I mean, it's a centralized process.
So
Centralized decision-making, which is just the opposite of Walmart.
So I think yes and no. Yes, in the sense that there is a centralized decision-making process, and all the appeals are routed to the Air Force Surgeon General, but only if a service member appeals. If he or she chooses not to appeal, the initial denial is the one that sticks. And those are quite dispersed through command levels across the Air Force. Moreover, the medical and administrative exemptions are granted by a whole disparate set of either medical providers or unit commanders in the case of administrative exemptions. So it's actually more similar to Walmart than I think you might think at first glance, in that there are quite a number of decision makers with respect to each of these different...
There's one Secretary of the Air Force, and there's one Secretary of Defense.
There's one CEO of Walmart.
Yeah, but
the policy...
But it's not a military hierarchical structure. It wasn't in that case.
But there's no evidence here that the sort of hierarchy of the military is being dictated by Secretary Austin or Secretary Kendall to say...
There's no discovery either. But
the policy in Walmart was specifically designed to allow diverse local decision-making. So the employer in Nevada could rely on testing, the employer in Connecticut could rely on more subjective factors, and we wanted diverse hiring practices. I don't take the government to be arguing that two individuals engaged in the same basic functions, one could get the exemption and another could not, even though they're engaged in largely the same tasks, because their immediate supervisor applied very different standards. I would think that the government would have an interest in uniformity of application just for basic fair treatment across service members.
Oh, absolutely. And the government does attempt to treat like alike, as RFRA does require. But I think there's actually an important premise to this entire line of questioning that we've glossed over, which is that these different kinds of exemptions, and we've not had an opportunity to address this, are fundamentally different. That the religious exemptions are granted or denied for very different reasons than the medical exemptions, for example. And contrary to plaintiffs' assertions, there is no blanket policy to grant medical exemptions as a matter of course.
Well, it almost seemed to me, in reading your briefs for these appeals, that you make the very distinction. You definitely emphasize this distinction more between permanent injunction or permanent exemption here, and the other ones are temporary. And it seems like the government comes close to saying, and we're entitled to deny the permanent ones categorically, or at least have a pretty strong default that we're going to deny them. Am I misreading the government's position? It's almost like you're sort of saying, yeah, we're basically denying almost all these. I mean, the numbers are the numbers, and that's perfectly fine. That's legitimate. We have a good reason because we just don't do permanent.
So far as there are no other permanent exemptions granted. So far as there is, and that would be a neutral law of general applicability, that no service member,
Maybe, but
sure, but no service member is entitled to a permanent exemption from being able to be deployed. And that's because in the Secretary's assessment, both the Secretary of Defense and the Secretary of the Air Force, they maintain a force that is deployable at all times.
why can't you just do, I mean, what Mr. Weiss, he sent us a 20HA, which I'm sure you've seen, and it seems to say, you can enter an exemption, and then if something for real comes up, like, okay, it's not hypothetical, we need you to go somewhere in the world or whatever, then you could revisit that exemption if and when a genuine need arose, as opposed to these sort of, hypothetically, you might have to deploy in 2 years, and so now we're going to deny it and terminate you, separate you from the Air Force.
So I think there's a number of reasons why there's meat on this particular bones here, and that's because to be fully vaccinated, you need at least a 4-week lead time, as you and I may be familiar.
Okay. So then it's like, okay, we can see okay.
Go ahead. But as Lieutenant General Schneider explained, in response to the recent Russian invasion of Ukraine, a mobilization was required in 24 to 48 hours. And a number of plaintiffs' commanders submitted declarations saying that they need to be able to deploy on as little as 72 hours' notice. In fact, one of the plaintiffs here services aircraft that are involved in special operations missions, which may be called to action on a moment's notice. And that's the function of the military, that they need to be able to be ready for any eventuality. And so maybe a different example would be helpful for context of the kinds of circumstances in which the permanent religious exemption would be granted. For example, a service member with an overly long beard. That beard could be trimmed like that, and he or she would be ready for deployment. And that is completely unlike vaccination, where service members need to be ready to go at any moment in time. And
I guess, this is a little bit stepping out of the line we're on, but what exactly, listen, I'm not an anti-vax person. I've had 4 shots. It didn't stop me from getting a nice case of COVID in August. But what exactly is the government's medical premise about how this so undisputedly advances this compelling interest, the very one you're talking about? We need people to be able to deploy, and why is it that somebody who's got natural immunity, whatever that might be, why that person is just so obviously not ready to deploy as the person who got 2 shots a year and a half ago. You know, I had it in August, or somebody had it in August, and they can't deploy. Oh, no, that can't happen. But somebody who got the shot in, February of 2021, they're ready. I mean, is it that you don't get the disease? Because you do. Is it hospitalization? Because why doesn't natural immunity work for that? I mean, I just have to voice that. I mean,
Of course, I understand, Judge Kethledge. So I think there's 2 responses that I'll make. First, with respect to natural immunity, there is no FDA-recognized way to measure, there's no serological testing that can actually determine that the FDA recognizes is reliable the level of antibodies in your system that would effectively provide protection against a subsequent infection. Moreover, natural immunity, just like the immunity provided from vaccination, wanes over time. And there is no evidence in this record when any of these plaintiffs were actually, when they actually contracted COVID, or the level of symptoms that they suffered, because the antibodies that your body generates vary with the severity of the infection itself. Moreover, vaccination is singularly effective at preventing severe illness and hospitalization. I hope in your recent case, for example, that you only suffered mild symptoms.
It wasn't fun.
But but in any event, the military needs to be able to take as many precautions as it can to mitigate adverse outcomes. That's why, for example, it requires 9 other vaccinations, including for tetanus, which is not spread person to person. And in fact, all of the plaintiffs here would have had to submit to those vaccines to enter the service. And I'm merely articulating that as a rhetorical point, but which only to underscore that it's the military's interest, just as they're going to equip service members with the best body armor that money can buy, that vaccination is essentially akin to that, which is it's the most protective measure to prevent severe illness and hospitalization while these service members are deployed and protecting the national defense. And there's no other means to be able to provide the same level of protection.
Is it a 2 shots and done regimen, or does the Air Force currently require boosters at a certain interval?
The Air Force has not instantiated a booster requirement, Your Honor, no.
So, I mean, query whether that undermines the idea that, I don't know, whether it undermines that reasoning at all. I mean, if somebody got the shot a year and a half ago, there probably aren't a heck of a lot of antibodies left for that either. And yet that person is allowed to deploy, and there's no problem with that person. But someone who even 2 months ago or a month ago got COVID, that person is going to get removed from the military unless he or she gets a shot. I mean, I know that we can only review this sort of thing so much, but I'm just scratching my head a little bit about the logic of some of that.
So I think there is, again, a lot to unpack there. For one, if the extent to which you're concerned or uncertain about a booster requirement, if anything, that requires deferring to the military's evaluation of public health expertise, because, and the availability of the booster itself exemplifies the extent to which the COVID-19 situation is constantly evolving and involves deeply uncertain science that the military is just trying to do its best in light of public health authorities' guidance. And that is the kind of thing that's not the province of the judiciary to question. And
yeah, no, I mean, to some extent, that's fair. I mean, I'm not so sure if the Air Force is the world's greatest expert in epidemiology, and whether necessarily we defer to them or whether there would be some experts. But anyway, I mean, we're not going to adjudicate that. I just,
sure.
Just as a just contextually, I was kind of wondering exactly how this advances things in every case.
We are also a bit far afield from class certification.
Yeah, that's my fault.
No.
So go ahead and, I took it.
Can I ask one
Go ahead, of
question?
course.
Yeah.
So we talked about RFRA, and then Judge Kethledge asked about the First Amendment. How do you, I kind of find the status quo of the First Amendment in the military context quite confused in how Goldman interacts with Employment Division versus Smith, and then the exception for discriminatory laws. Does that impact class certification? The court has told us at the class certification stage, we're supposed to look forward to the merits to determine whether there's a common question. And I'm curious on if the government has a position on how Goldman applies. So Goldman arguably was a neutral law. If anything, it went from rational basis to nothing at Smith. But if you say the military has what the Supreme Court today would consider not a generally applicable law, would it trigger strict scrutiny under Sherbert, or would it just go back to Goldman's rational basis review? And do we need to decide this or even think about this in determining whether to certify a class for the First Amendment question?
You only need to reach the First Amendment question if you disagree with us, or if you agree with us on RFRA, because the RFRA incorporates what is essentially a strict scrutiny requirement. And so if you agree with us on RFRA, then you would reach the First
But your
Amendment.
theory on RFRA for class cert is that it's different than the First Amendment because it doesn't have this process-based idea.
Right,
And the
right,
First
apologies.
Amendment might have a process-based idea.
Yep.
And then my question is, well, okay, if we get to the First Amendment, we'll have to start adjudicating the merits of what I view a little unclear law about how all these cases interact with each other.
Right.
And I'm curious.
Yeah, now I understand. Sorry. Well, first, the threshold point that I will make is that we believe the vaccination requirement is a neutral law of general applicability. The fact that there are exemptions granted for other reasons does not defeat the notion that there is a religious exemption process separate from that. And the First, Second, and Ninth Circuits have rejected challenges to vaccination requirements for exactly that reason. The availability of other kinds of exemptions would not necessarily trigger strict scrutiny. And this Supreme Court's decision in Fulton is not to the contrary. There was a separate process on how the particular exemption claims were adjudicated that I don't believe bear on the First Amendment question here. So because it is a neutral law, then rational basis would apply. And then you don't get into complicated questions of Goldman's continuing viability in light of Smith.
Well, there is, I also find the Supreme Court's case law somewhat unclear on how we determine whether it's a neutral law. I've articulated the idea that it's strict scrutiny to determine whether strict scrutiny applies in some contexts with Tandon and other of these things. It's like really scrutinizing whether these distinctions hold up. The distinctions between what is allowed and what is not allowed and those cases. And so I'm curious, I wonder if Goldman could somehow apply in the military context to these distinctions as well, about whether medical is similarly situated to, or there's a difference between medical and religion. Could we say that we have to scrutinize that? Could we say that Goldman would apply to the scrutiny, and so it would almost be a rational basis test to determine whether the military has a valid basis for distinguishing between the two? So I do think that we have to engage in some type of scrutiny. How closely, like it's an equal protection type scrutiny. Are these things similarly situated? And even under equal protection, there's rational basis and there's strict scrutiny.
Mm-hmm. But I think determining whether the government has sufficiently articulated a compelling interest and whether the military has effectively refuted the notion that there are less restrictive means of satisfying that interest are questions that Goldman informs on the extent to which you defer to the military's judgments. So even when you're applying that standard of review, it's not exactly the same as strict scrutiny in the civilian context, for example. And it's not just Goldman, but the Supreme Court in Winter articulated something similar, that although not a RFRA case, the kinds of questions that the courts defer to the military on are exactly those which should contemplate expertise-driven judgments, which is exactly what the COVID-19 vaccination requirement is.
Any more? Okay, great. You'll have your full rebuttal. We'll hear from the plaintiffs.
Your Honors, good afternoon. I wanted to begin with the issue that we raised in our response brief in the 3702 case, which is whether or not this court even has jurisdiction to consider the class certification that Judge McFarland entered. And that rises and falls with the inextricably intertwined analysis that this court engages in.
It's been pretty intertwined so far this afternoon, but
Well, Your Honor, with respect, we disagree with that. And the reason is that the review of the injunction itself undertakes a different analysis and a different standard of review than the class does. And we know that in part because if you look at the government's brief, they separate it out, and they're citing cases about class certification. versus cases about whether or not the injunction factors were met. For instance,
Why wouldn't it just be likelihood of success? I mean, it's a lower standard of review for them. I would concede that. But if there's a likelihood of success that we would decertify the class, then doesn't that satisfy that likelihood of success factor? It's just not a merits question anymore. It's more just whether we're likely to think that the class was improperly certified, and if we think so, then that would take care of the injunction.
Your Honor, obviously,
So it's not de novo review of the class certification, which they would have gotten under 23F, but it's just wrapped into the likelihood of success factor for the purposes of the injunction. It was a class-wide injunction, and if we find that the class was improperly certified, then there was no basis for the injunction.
we think those questions are separate, Your Honor. That the propriety of the class certification is separate and apart from the propriety of whether or not, on a class-wide basis, in light of the certification order, Judge McFarland appropriately entered class-wide injunctive relief.
But, I mean, to a large extent, both injunctions rely upon the same theory on your part, which is that they have a blanket policy of discrimination.
That is-
Like, why isn't that enough of a common thread here to make these things intertwined?
Because the class issues raise their own legal and factual issues, which actually one of the cases cited by the government in trying to rebut the jurisdictional argument says. Their Hidden Ballage LLC versus City of Lakewood case. That
I mean,
case
it's
says,
not going to be a complete overlap. We don't need complete identity of issues, but, you know, there's some degree of, if we decide this thing in this case, it's going to drive the outcome in the other case, and that would seem to be present here.
Your Honor, it has to completely dispose of the question. In other words, there has to be a direct alignment. It's not they're somewhat related. There has to be a direct alignment under this court's precedent to trigger pendant jurisdiction. And so we question that. And I wanted to begin there. We're not conceding jurisdiction. We think there's a serious jurisdictional problem. Turning to the standard of review, again, the standard of review on the class is an abuse of discretion. The standard of review on the preliminary injunction is an abuse of discretion. And that's highly deferential. The district court found facts in terms of this, at a minimum, bias towards denying these exemptions. We would submit that there are no standalone exemptions on this record.
There hasn't been any discovery in this case, right?
Right.
You guys didn't ask for Rule 23 discovery, right?
We did not,
Or
Your
you
Honor.
sought certification. And so, like, on what basis is the court finding facts? The court can't find any facts. It can just assume for purposes of a motion to dismiss or for, you know, the motion before it, assume certain things. But how is it finding things?
Your Honor, there was an evidentiary hearing that was held in this case in which we put on testimony. The district court asked the government if it wanted to adduce any hearing or proof. It declined to do so. One of the things that's interesting about the proof of record with the exemptions, that's always been evidence that's been in the control of the government and solely in control of the government. And one would think if the government, for instance, was going to have proof that it was granting standalone exemptions, perhaps we would have seen some of that proof below. And we did not. You are correct.
Do you think, so set aside the policy and the basis for the stay order, just RFRA in the abstract, I think you would concede, requires an individualized analysis. That's the entire point of Ocentro. So setting aside the policy or practice theory, in the abstract, would you say that RFRA claims are not generally susceptible to class-wide treatment as long as the government is actually engaged in an individualized analysis?
I think it would depend on the facts and circumstances. I think the claims here could be, for the simple reason that the government is granting robust secular exemptions to the same policy. And so for that reason, especially when you look at the class definition that the court certified below, you've got a class of people who have sincerely held beliefs that have been substantially burdened by the mandate, by definition. And so you've through that definition, placed the onus on the government to come forward and meet its burden of proof. And I think you could adjudicate them in the abstract on these facts because of the fact that the government is granting blanket exemptions, for instance, to pregnant women. And of the record below, for instance, is Major Corby. Major Corby asked for a religious accommodation. The government told her no. Major Corby became pregnant, saw a military doctor. Yep, you're pregnant. Here's your medical exemption. that's a blanket policy. Everybody that's pregnant that asks for an exemption, they grant.
So is that the First Amendment claim, though, or is that, how does RFRA take into account discrimination? So what's the theory for why that type of discrimination would violate RFRA?
Your Honor, it goes to the heart of both the compelling governmental interest as well as the issue of least restrictive means. If the government is able to accommodate other people for secular reasons, then obviously they're able to accommodate religious believers for the same reasons. And there are cases that suggest as much in both the First Amendment context. Incidentally, I think this court's decision in Maryville overlapped the analysis. And there you dealt with a state RFRA, but it's the same standard in Maryville as the federal RFRA. It's still a government requirement to show a compelling governmental interest in least restrictive means.
What would be so class certification requires a common question?
Correct.
Under that view of things, would your view be, the common question would be, does the government have a compelling interest in refusing to grant religious exemptions if it grants medical exemptions? And that could be certified on a class-wide basis with a yes or no answer to every class member?
We think that is correct, Your Honor. It's absolutely the case. If the government is granting and permitting secular exemptions, it has to grant religious exemptions that are comparable.
How would you respond to the government's argument about how RFRA doesn't even care about process and they don't even have to grant any exemptions, and that is not subject to class treatment because once you get to court, it's going to be an individualized inquiry?
So, Your Honor, my reading of 42 U.S.C. 2000 BB subsection 1A is clear that it imposes a requirement on the government that it is not permitted to substantially burden religion, subject to the exceptions in subsection B. And to adopt the government's theory is to read out parts of a statute, particularly subsection A and B, and to move right to C, the relief section, if there's a violation. With all due respect to the government, I find that position incredible. Under the government's theory, for instance, someone could go out and murder somebody. It's prohibited by statute. No problem with it until you're hauled into court and you're charged with it. Well, we all know that you can't murder people. It's illegal. You can't substantially burden religion unless you have demonstrated the exception, and that happens before someone goes into court. If it were only a remedy court process, well, we wouldn't see, for instance, the government's own regulations that require this robust processing, for instance, in a Department of Defense instruction or in an Air Force instruction, all of which reiterate the fact that they can't burden religion unless they establish a compelling governmental interest in least restrictive means. So we look at that argument, Your Honor, and I think it is divorced from the statutory language to begin with. It's divorced from common sense as a second, point.
Outside this context, have there been other RFRA class actions that you know of certified?
Your Honor, when you say outside of this context, you mean other than other branches of the service?
Yeah, just kind of the current litigation that's going on right now.
I am
It's been around for 20 years or 30 years, 1993 or whatever, so I guess
I am unfamiliar with whether or not there are any others. Obviously, there are each of the branches of the service, there are similar claims regarding the Marines. The Navy obviously was certified first, and so this is not unprecedented. Other courts are taking these things up. We do believe that there's a process problem. If the government, for instance, was completely ignoring RFRA and just there was no process at all for exemptions, that would be an issue, and we think there is a systemic class issue. This is right in line with a Title VII claim, for instance, that have been frequently certified. And there's obviously religious freedom is protected under Title VII, not as vigorously as it is in RFRA and the First Amendment, but those classes have been certified, Title VII claims, and employment discrimination cases have been certified frequently. I did want to address, if I could, because I think the government has brought it up, the distinguishing aspects between what we have in this case and Walmart versus Dukes, because I think that really gets to the heart of the issue. In Walmart, there were 1.5 million class members, thousands of decision makers, all of which were occurring at the individualized level. And the Supreme Court held that the evidence was not sufficient because it rested largely upon a sociologist's testimony where that expert testified he could not determine whether 0, 5%, or 95% of the decisions were driven by stereotypical thinking. And the statistical evidence was equally insufficient because it was a regression analysis that looked region by region and didn't determine discrimination at the lower level, store level, where it was allegedly occurring. And the Supreme Court noted, I think correctly, that, quote, other than the bare existence of delegated discretion, respondents have identified no specific employment practice, much less one that ties all their 1.5 million claims together. Well, here, Your Honor, we have a 99% denial rate, and we have concessions by the government in a different case that the 1% were end-of-service personnel, and you just heard another concession today that in fact was the case. I think we heard the one-year window out of government counsel. That is the exact opposite of Dukes. And in Walmart, one of the things that the Supreme Court said was that you would not get common decision-making like that unless there was a decision from the top, right? And that was the language in Walmart. And yet here we have common results coming out of this government process. We have a common practice and policy that's been driving all of this. We have a vigorous thousands of secular exemptions and comparatively a very small handful of religious exemptions, all of whom are on their way out of the service anyways.
What do you think Walmart means by significant proof of a general policy? It's not clear to me how that would even work. Is it like on the merits? Is it because it's supposed to be different than class certification is supposed to be different than merits, and so is significant proof just enough to survive a Rule 55-6 genuine issue of material fact, or is it a fact question for the district court that we would review for clear error?
So
I read the opinion and I was quite...
Right. If you look at Walmart and you look at footnote 10 of the Walmart case and the Supreme Court's discussion in it, it talks about what that proof needs to look like in a pattern and practice case. And it suggests that the pattern and practice needs to be established by a preponderance of evidence. And so that's
At the certification stage?
That, Your Honor, they're citing it in a certification decision, and I think that that's a reasonable conclusion
Wouldn't
to draw
that
from
suggest that you should actually not just grant certification, but grant judgment to the plaintiffs?
It would certainly suggest that at the end of the day. Obviously, a preliminary injunction hearing is just that. It's preliminary, it's not binding, and
Well, it's not. It's a class cert hearing. It's not a preliminary injunction hearing.
Right. Right.
Yeah.
And in a class cert hearing, again, the standard of proof for what is needed in terms of the Rule 23 factors, it's never been abundantly clear to me about what that needs to be. But here, I think the proof was that it was at least the preponderance of the evidence that established this policy.
Here?
In this case, Your Honor.
So catalog that for us, the proof itself.
Certainly. The proof below was, again, that there were, and I think Judge McFarland cited some of that proof in his decision itself. One of the things he cited was the systemic violation of RFRA, the 9,062 religious accommodation requests, the granting of 86, the denying of 6,343, the granting of 23 on appeal, the granting of, conversely, 729 medical exemptions, 1,006 administrative exemptions.
So we all know about the disparate rates for the different kinds of exemptions.
Right.
What else? Anything?
Your Honor, in addition, obviously, the concessions below by witnesses like Colonel Pohl, who suggested that in part they were reserving the religious exemptions, they were not granting those to afford more medical exemptions.
I had a hard time teasing that out between the lines of Colonel Pohl's affidavit or declaration.
Well, Your Honor, he suggests, he
He
says
didn't
the
really say
right.
that. I mean, I don't know.
He says in part, if we grant these religious exemptions, we're not going to be able to use them for people that have a medical need for them. I mean, he says that at paragraph 7 of his declaration.
Okay, take another look at it. I'm not saying you need a preponderance necessarily, but that's a strong statement at this stage of the case.
It is, and I'm not sure we need it either. The Supreme Court certainly suggested that's going to be sufficient, and maybe that's sufficient. Well, we know that that's sufficient at the end of the case, at the end of the proof, that it's more likely than not. Even if that is the standard, I think it's met here. I think the statistics bear it out. In addition, when you look at the evidence, for instance, of the government granting medical exemptions to people like Major Corby at the same time that they're denying religious exemptions to the very same person in the very same circumstance, There's nothing different about her job duties that changes, right? And
But what do you say about the government's distinction, say, in that very example, that one of these exemptions is permanent in the government's view, and the other one isn't?
Your Honor, we submit that that's simply litigation posturing on the part of the government that's divorced from the actual regulations that suggest that all of these religious exemptions are subject to an ongoing review and, frankly, withdrawal if circumstances change, which is what the plain language of the Department of Defense instruction says at 1317, subsection B, as well as subsection G and subsection H, as well as that relevant Air Force instruction that talks about circumstances changing and the ability to withdraw them. And so that's no different than granting a quote-unquote temporary medical exemption and giving somebody an exemption for as long as they are, for instance, they're either pregnant or for as long as they have some sort of allergy, all of which the government is robustly granting. Those continue in force for as long as the condition persists. The same is true from the religion. They're just talking about who initiates the withdrawal. In other words, in the medical context, they're subject to renewal as they come up, and the members got to go and have the doctor look at them again. In the religion context, the commander can withdraw those at any time if the circumstances change, and that's what the regulations suggest. And so this distinction that the government tries to draw that they're somehow different is belied by the plain language of the policies themselves.
I wonder if this debate is for the merits, and the actual critical issue here is whether this is a common question, whether medical and administrative exemptions are analogous to the religious requested exemption. If at the certification stage, all you have to say is, yeah, those are common questions that can be litigated on the merits, then that's all you need for proving certification. You don't actually have to prove at this stage that they are the same, and therefore you should win under, the First Amendment or RFRA.
That is true for the certification question, Your Honor, that those common questions drive, for instance, that the question, are these exemptions the same? Did the government actually engage in an individualized analysis? Did the government meet its burden generally with respect to these people? There's a number of common questions. Does the government still have a compelling interest for any of these vaccinations in light of the recent CDC guidance that says natural immunity is equivalent? There are several common questions, all of which, by the way, aren't just common questions, they have common answers, which is what Walmart fundamentally asks. Obviously, when we get to the question of the class-wide preliminary injunction, there we're looking at, did we establish a likelihood of success on those questions? And we believe, again, given the proof here, that we did. The government, I think, would concede that any member of the Air Force that is pregnant that walks in to see the doctor gets an automatic exemption. Any member of the Air Force that's at the end of their term of service gets an automatic exemption. Any member of the Air Force who is not vaccinated and gets a placebo in a vaccine study gets an automatic exemption. Those are granted on a almost blanket basis, and yet there's a systemic denial, all of which demonstrates both a lack of general applicability under Tandon and Fulton, triggers strict scrutiny, and the government on a class-wide basis is going to be unable to make that showing given the robust exceptions that it grants.
That question, I thought on the class cert appeal, I thought it was only about whether Rule 23 was satisfied, and that was all they were presenting to us. I don't know that we have to look at the merits.
They did make it was an anemic argument, Your Honor, at the end of their brief on the actual the preliminary injunction itself. They did go beyond the class certification issues. We believe the record here supports that just as the preliminary injunction was appropriate for the 18, it was equally appropriate for the class, who were subject to the same discriminatory policy. Your Honors, if there's any other questions, I'm happy to accept them on the class questions or the class-wide PI.
You got any? Eric? Okay,
Thank you,
thank you
Judge.
for your argument. We'll hear rebuttal from the government.
Thank you, Your Honor.
I'm going to start with just a brief roadmap. Start with Ocentro, move to 23B, which we haven't discussed yet, and then finally move to the equities, which were never addressed by the district court.
Very well.
So first, starting with Ocentro, the Supreme Court left open the possibility of a uniform application of a law so long as the government proceeded with individualized adjudication of particular exemption requests, and found that it would be permissible under RFRA. Ocentro foreclosed a categorical rule at the outset if there was no individual adjudication of exceptions. But it left open the possibility that there might be uniform application of a law or policy that admitted no exceptions. And the 11th Circuit held exactly that in Grady in rejecting a Catholic protest group RFRA challenge to a policy prohibiting protests on naval bases on exactly that reason. And that's similar to longstanding Supreme Court precedent rejecting religious-based exemptions to Social Security taxes and income taxes and the like. And so the same logic, if the court determines that there is something akin to a blanket policy, which there's not, here, that would not necessarily.
But would that be certifiable as a class then, right? Wouldn't the government prefer having a class and having that answer? Because then the answer would bind everybody.
Oh, no, I was going to say, Your Honor, but that would not admit of a RFRA violation. So there wouldn't be a certifiable class on that basis because there's no underlying statutory claim to certify. On 23B, which we've yet to address, I just wanted to point the court to the fact that the service members here, roughly 10,000 of them, have heterogeneous interests that this court in Coleman held would not make a class susceptible to class-wide adjudication. There's something around 150 service members that have sought to opt out or have pursued separate litigation individually. There are currently 9 cases pending of different individual service members requesting individualized relief. And in 2 of those cases, pending in the 8th and 9th Circuits, in light of the substantial confusion caused by the district court certification order here, those courts have requested supplemental briefing following oral argument about what to do in those cases.
Well,
and
I don't see any conflict between other courts adjudicating what I would call individualized RFRA claims based on the particular circumstances of those plaintiffs, while another court adjudicates class-wide the question whether some kind of class-wide treatment of religious applicants for religious exemptions is unlawful. It's 2 different claims.
So I respectfully, I continue to disagree whether there are 2 claims because it is our understanding.
No, I understand that.
Yeah.
And of course, that got a First Amendment claim, which obviously would address, would reach a discriminatory policy.
Sure, but I think still the relief for a First Amendment claim would be similar to that which would be provided under RFRA, which is effectively an accommodation. And the Supreme Court in Colorado River explained
Not
that.
necessarily. Remember what we said in the stay opinion. It's not just, you get permanent exemption. It might be, okay, go back and do it with a non-discriminatory process.
But it's worth emphasizing that's not, so far as I understand, what the district court ordered here. It's certainly not with respect to the class-wide preliminary injunction.
we kind of had this talk.
Yeah, absolutely.
The court said, don't fire anybody in the meantime.
Right,
That's what
right.
the court said. And the outlines of a permanent injunction, if that ever, comes to pass, that's kind of what you're talking about now would bear on.
Right. I guess I wanted to emphasize, Your Honor, that there are individuals here who have sought relief on an individualized basis, which would substantially call into question whether the class could be certified under Rule 23B. This panel recognized in its order denying the stay that it's questionable whether an opt-out regime could even be permissible under Rule 23B2, specifically because those circumstances are usually certified where there's homogeneous interests across the class. That's not the case here. Over 100 service members have already sought to opt out because they're otherwise bound by, or would be bound by judgment in this case.
But they wouldn't be bound in the individual. I was concerned about that too, but there was, the FDIC case, Cooper versus Federal Reserve Bank of Richmond, suggests that for purposes of res judicata, I think that's the case, it would bind them with respect to the general claim that a policy or practice does not exist, but they could still pursue their individual claim that even if no policy of discrimination exists, I was discriminated against in my own individual case. Now that was I don't know if it was Title VII or it was some type of discrimination claim, but I would think that the same analysis could apply here, that of course a pattern or practice judgment against the plaintiff class would bind the plaintiff class with respect to the question of whether a policy or practice existed, but it would not bind individual claims for individual RFRA relief or First Amendment relief.
Sure. So setting aside whether that's what the district court certified and whether that's something that RFRA actually provides for, I guess if that's the understanding the court has of the class certification, that probably wouldn't bind individuals who have sought individualized relief. But so far as we read the district court's preliminary injunction, that does conflict with what other service members have sought in other cases. And
Well,
so
it's said over and over again, a blanket policy of discrimination. I mean, that's not talking about individualized analyses. That's you're rejecting everybody. You're giving categorical treatment. That's discriminatory. So that's what he's saying. You know, the class-wide thing.
he may have characterized the policy as such, but if you turn to plaintiff's complaint itself and their motion for a preliminary injunction, it specifically requests an accommodation. It does not challenge the policy, and it requests enjoining the policy or the implementation of that policy, but rather that they be effectively given a permanent religious exemption to the vaccination requirement. So, I mean, again, tomato,
Talking
tomato.
about the same thing again.
Yes, I know, apologies. But I think it is important in my remaining time to address a critical flaw in the district court's granting of a class-wide preliminary injunction, which is wholesale ignoring of the equities. The district court's 4-page order never addresses irreparable harm or the balance of equities, when here, granting relief to something of 10,000 service members is materially different and imposes a substantially greater burden on the Air Force than with respect to 18 individuals. And the district court never even addressed this concern. The Air Force submitted a number of declarations from senior military officials attesting specifically to how there would be greater harms to the military and its ability to respond to global conflicts were class certification granted and a preliminary injunction given against the Air Force.
But again, the military, I mean, itself grants a temporary exemption while applicants are having their requests considered, right?
That's correct, but in this particular case, there are something of 3,600 service members whose appeals have been finally denied and who would otherwise be assessed for potential discharge from the military, but the Air Force can't do that. And those service members are occupying otherwise deployable billets that the Air Force can't fill with people who would be deployable. And those are serious concerns, even now where...
Well, I don't follow that because the injunctive order doesn't tie the Air Force's hands at all in terms of any operational decisions. I don't understand how the court's order would lock somebody into what you're calling a deployable billet or something.
So I think it was that the Air Force, so far as I understand, does not read the preliminary injunction to allow them to remove someone from a position that they're currently in, or the district court's order does allow, so far as we understand, but at minimum, the the Supreme Court in Winter emphasized that ignoring senior military officials' testaments of harm and failure to evaluate the balance of the equities in these circumstances is itself an abuse of discretion and basis for vacating the preliminary injunction. So we urge the court to vacate the preliminary injunction and reverse the class certification.
Okay.
Unless the court has additional questions. I just see my time is up.
All right. We don't have any further questions. Thank you both for your fine arguments this afternoon. And you've both been very good sports in fielding all of our questions. Thank you. And we will give this case very careful consideration and get you a prompt answer per the terms of our earlier opinion. You can adjourn court.
This honorable court is now adjourned.